We begin in the 14A District Court, Washtenaw County, Michigan.
Court calls the case of the people versus Donovan, Friel.
Assistant Public Defender Jay Ballinger on behalf of Mr. Friel, who appears via Zoom. Mr. Friel, can you please state your name for the record?
Donovan Friel.
And Your Honor, we are seeking to adjourn this for possible media discovery on this matter. I'm not currently in receipt of any.
Mr. Friel has private attorney, Mr. Sam Bennett.
Oh, does he?
Do I have a substitute?
I don't have one.
This has got other counsel, but I have not signed the substitution.
Your Honor, I was not aware of other counsel myself.
Who's the attorney?
It's Mr. Sam Bennett. He's in the
Mr. Bennett?
Yes, good morning, Your Honor. Sorry about that.
Are you representing Mr. Friel?
I am, Your Honor. Yes, we sent in a substitution yesterday. And Mr. Bellinger.
Was it signed off by the PDs?
It wasn't yet. We are just retained yesterday, so it was kind of a rush.
Where'd you send it? Because I don't have it.
We sent it to the public defender office waiting for a signature.
So the real answer to that is no, he's not representing him today. You're requesting an adjournment?
Yes, Your Honor. It sounds like Mr. Bennett would need that anyway, so.
Yes, that is correct, Your Honor.
September 25th, 2025, 9 a.m. bond continues.
Your
Thank
Honor,
you.
Your Honor, given that I'm on the case or will be on the case shortly, could we do the following week, please, the 2nd, just to make sure that I don't have a conflict?
October 2nd.
Thank you, Judge. And we'll get to that.
Hold on a second. Hold it. What?
The Tuesday the 30th or October?
Oh. September 30th. That's a Tuesday, 2025 at 9 a.m.
That sounds good, Judge. Thank you.
Thank you.
And then, Your Honor, very briefly, Mr. Friel would like to travel to Indiana in the next.
Then he can tell his attorney in the case, and then I will consider his request.
Okay, thank you,
I
Judge.
need the substitution before you start talking on his case.
I understand, Your Honor.
Thank you. Court does call the case of the people versus, is it Santasha, Callaway?
Then on behalf of the people, Your Honor.
Particular on behalf of Ms. Callaway. Judge, did you say your name?
Santasha Callaway.
Judge, I met with my client. She would like to pursue the matter through a preliminary exam. Judge, I'm wondering, probably sound like I'm whining.
Discovery complete.
Yes, Judge. Is it possible we can make it out to September 30th?
Anything's possible.
Well, I know with you, Judge, it is.
Well,
I got a few more cases coming up. I'll be whining.
what'd you say?
Nothing. You're a great judge. That's what I said.
What did he say?
Judge, we have a big docket. We should move along.
People have their witnesses available the 30th.
We'll do our best, Your Honor.
All right. Preliminary exam. Will that date work for you, Mr. Kilwell?
That's the date I asked for. Thank you very much.
That was the date you asked for?
Yeah. Thank you for your
I
very
don't know why I'm
considerate.
doing it. Preliminary examination in person, September 30th, 2025. That's, gee, Mr. Kilwell, we'll see each other again. That's at 12 o'clock.
Judge, you're very
noon before
considerate this
me.
morning. You're very considerate this morning. Thank you. So
Bond will continue. Does he have any more? No. Court does call the case of the people versus Sean Edgar.
Edgar. Morning, Rob J. Kilwell on behalf of Mr. Edgar. Judge, I was just appointed late yesterday afternoon. I don't have any contact information because I was appointed so late. But I would respectfully ask the court to grant a 2-week adjournment.
All right. Well, he also has a violation. He's not reported to community corrections, so
I got
we'll
that.
issue bench warrants on both cases. Bond is setting him out at $25,000 cash surety. Those warrants will issue immediately.
When will they kick in? Now?
As soon as they get to my clerks, they're going in.
Would the court consider maybe, no,
No.
I've used up my.
All right, thank you. Just trying to move it along, Mr. Pillowell. Court calls the case, People versus David Rasmussen.
People.
Just following your advice.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Mr. Rasmussen, who approaches the podium.
Your name, sir?
David Rasmussen.
All right, what are we doing?
Your Honor, discovery in this case is complete except for the 911 calls. I've spoken with the prosecution. Those are already been ordered. We're asking the court to set this for an exam, please.
Your Honor, it should be involved before the exam.
All right. I'll mark that if they're not in, you would not be entitled to an adjournment based upon not having those. But people have their witnesses available the 16th.
We'll do our best, Your Honor.
Preliminary examination will be set September 16th, 2025, 9 a.m. That's before
Judge Perry.
Judge Perry.
Thank you, Your Honor.
Bond will continue.
Your Honor, may I address bond?
Briefly.
Your Honor, Mr. Rasmussen is a general contractor, self-employed. He's been in custody for some time now. We understand these charges are somewhat serious. However, reading through the discovery, I think that a personal recognizance bond with a no contact order would be appropriate in this matter. He's not to go to the address where the complainant is living, and he just wants to try and get back to work. This is his busiest time of the year with painting and getting people ready for the winter. And quite frankly, his 1987 pickup truck's in impound anyway. He's not a man of means, Your Honor. So $2,500 may as well be $250,000 to this man.
Respond.
Object to any modification of bond. In this case, the defendant was angry at the victim because he thought she was sleeping with someone else. He then pushed her on the bed and strangled her with two hands. He later punched her in the face, and she had bruising around her eye. He also took her phone so she couldn't call 911. And when officers asked her about the strangulation incident, she said it's happened previously 4 times in the last month, and he always uses both hands and tries to make her pass out. So I have great concerns for her safety. I would also ask for, if he is released at some point, I was not sure if the tether was ordered, a GPS tether. That to be ordered, but it's just how I reject any modification of bond.
It looks to me like it was ordered stuff. Anything else, counsel?
Your Honor, I don't want to get into the merits of the case, but the same report also indicates that the victim was the first to be arrested till she changed her story and they decided to issue the warrant against my client. Additionally, she indicates she doesn't want to prosecute my client. So we can read the report or we can read the whole report, Your Honor. I don't believe he's a danger to the community at large. He has a very minimal record of one operating while impaired, I believe 7 years ago. I don't believe he's a danger to the community. He's a homeowner in Ann Arbor. He's lived here his whole life. He's 56 years old. He just had his birthday in jail over Labor Day. We're just trying to get him back out so he can work, because otherwise he's probably even going to lose his truck if he can't pay the impound fees on that. And again, we're talking about a 1987 pickup, Your Honor. We're not talking about a very wealthy man. He was willed the deed to the house from his mother, and he lives in his family home.
Well, at this time, based upon the information that's in front of me, I'm not going to change the bond. I wouldn't find that the magistrate setting a bond would be an abuse of discretion. So motion for bond reduction is denied. Bond will continue.
Thank you, Your Honor.
Thank you. Court does call the case People versus Isaac Sepulveda.
And said on behalf of
Morning, Your Honor. Robert J. Cole on behalf of Mr. Sepulveda. Just state your name.
Isaac Sepulveda.
Judge, I've met with this young man. He wants to proceed through a preliminary exam. Discovery's complete. I would, with some trepidation, ask the court if we could do it for September 30th again.
Want so bad to say no.
Well, you being the considerate, kind judge you are,
Kill 'em all. September 30th. Will people have their witnesses available? I guess I should ask.
We'll do our best, Joe.
September 30th, 2025, 9 a.m. That is before Judge Washington.
Thanks.
Bond will continue.
Thank you, Judge.
Court calls the case People versus Annie Oglesby.
Good morning, Your Honor. Fellow people.
Where is she? Oh. See her. I thought you had enough yesterday.
Never. Never.
Your name, ma'am?
Annie Marie Oglesby.
Good morning, Your Honor. Tina Saxon for Miss Oglesby.
Okay, she's in. Got it. All right, thank you. All right. What are we doing?
Your Honor, there are now two cases. I just received
Yes.
the newest case yesterday. I don't have any discovery for that, but I did file my appearance and request for discovery yesterday. For the first case on this matter, I'm going to ask for an adjournment because there's an overlap between the two cases. It looks like it's coming out of two different jurisdictions, but for the same offense. So I'm asking for an adjournment so that we can track these together if the court is in agreement with that.
Yes, I will adjourn it. Currently, she's being, okay. Probable cause conference will be adjourned September 11th, 2025, 9 a.m.
Your Honor, since this matter, I have to ask for another date. I will be out of state, returning that day, but
I can do the 18th. Will that work?
yes.
September 18th, 2025, 9 a.m.
And Your
Bond
Honor, when
will continue.
approved, I'm sorry, there was a bond violation that.
Yes,
we
there
needed to-
was. Pardon?
Your Honor, as you remember on the first violation, Ms. Oglesby was in custody. The second one, she simply did not have the money. She had lost her job while she was in custody in the other jail. And she couldn't pay for it, therefore they would not allow her to test. And now she's in custody again.
She didn't report for intake. So I don't know how that happened.
She stated that she called and left 2 messages with the community health and never received a phone call back.
Well, my understanding is she didn't report. We sent over another order. She again did not report for intake or testing.
Again, yeah, she lives in Jackson, which I stated at the
Okay,
first
that's
hearing.
like 35, 40 minutes away. And she didn't report twice.
She could not report the first time, Your Honor. She was in jail.
I was in custody in Eaton County.
Right.
So
And
I understand
then-
your position, at least on the second time. She did not report for intake or test. And I'm just providing the explanation for the failure to test. It's not free and they would not do it without it, but I understand your position on the intake.
It's considered a dirty drop in Jackson if you don't have the money.
I don't know what that has to do with this. You didn't report to our community correction.
Ms. Oglesby, don't speak.
All right, I don't need a response. Motion for bond reduction is denied. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Melissa Kwinsky.
Chelsea Virgil with and on behalf of Melissa Kwinsky with approaches. Please state your name.
Kwinsky.
All right, what are we doing?
Your Honor, we're asking to adjourn to continue a plea discussion, and I would ask to address bond.
Of course you would. Is this the only thing holding her?
Yes.
Probable cause conference will be adjourned September 18th, 2025, 9 a.m. Yes to bond.
Your Honor, we're asking for a personal bond in this case. I understand she did have a violation, but she has a thorough plan to maintain sobriety, including through CMH, both substance abuse and mental health treatment. She has an appointment set up with them already, including also the Vivitrol shots involving with her church. She goes to AA. She's really worried about getting out to work. She supports herself financially. And I think that this plan can set her up on the right track. So we ask you to consider that.
What is the plan? That's the plan?
Yes, treatment, AA, church. I think all of those things would be a great support system for her. And she did just get out of inpatient treatment recently, so that is fresh in her mind. She wants a chance to show the court that she will comply.
She got out and then 2 days later, she's violating her tether.
It was admittedly a relapse that she deeply regrets.
Thoughts from the people?
Your Honor, we talked about this last week. I reminded the court that this was a hit and run with an alleged BAC of 0.28. I'm not saying that Ms. Kwinsky is somebody that needs to be in jail indefinitely, but I do think that we'd like to see it a little bit more concrete in any release with this grandmother.
Your Honor, may I respond briefly?
Go ahead.
I just wanted to point out that the incident allegation in this case was before her inpatient treatment, so she sought out that treatment herself. We have no objection to a scram tether, but I think
Didn't
that this,
she have a program for follow-up care after her treatment?
I believe so. I think that part of
Is
this
she
plan.
following that?
Are you following your plan?
Yes, I am.
And I think this is fairly
Oh.
concrete. She has an appointment on September 22nd.
After she got out of treatment, she was supposed to, there's another part of what her treatment would be. Did she continue with that?
What was the plan after treatment?
The plan after treatment was to go into IOP, which I did call CMH, but unfortunately, there was no opening until the 22nd, so I can have a 90-minute evaluation so I can get an IOP. I am still following up with Michael Francis, which is an outpatient psychiatrist in the meantime, until I can get in there on the 22nd.
So the answer to my question is no, she didn't follow up with that. And then secondly, then again, 2 days after that, outside of the facts of the particular case, she was drinking again. So, and I'm not really hearing a concrete plan that's consistent with the inpatient that she received. So for those reasons, the court is going to deny the request for a bond. In this case, bond will continue. Court does call the case of the people versus Jennifer Baker.
For the people.
Assistant Public Defender Jay Bellinger on behalf of Ms. Baker, who approaches, Your Honor. Baker, can you please state your name for the record?
Jennifer Baker.
Yes, you may. Probable cause conference will be adjourned to September 11th, 2025, 9 a.m. Bond continued.
Need to come back at the time.
No, and Your Honor, I just want to make clear on the record for Ms. Baker's purpose that if this case is dismissed, in fact, and I talked to the prosecution about that, you will not have to come back for the dismissal to issue.
Okay.
Okay? Is that correct, Your Honor? I just want to make sure that.
Sure.
Okay.
No, she doesn't have to come back
Okay.
because of the reason why there would be the dismissal. I wouldn't want to. All right. Thank you.
Okay.
So we will figure it out.
All
Okay.
right.
All right.
Court does call the case people versus Dearian, Macowski, Smith.
Morning, Honor. Raymond Cook for the people. Judge Callaway on behalf of Dearian Macowski Smith.
Assistant Public Defender Alexis Zerbs, also with and on behalf Mr. Macowski Smith.
Good morning, Your Honor. Dearian Cortez Macowski Smith.
All right. What are we doing?
Your Honor, there should be a green sheet submitted. We are respectfully requesting an adjournment just to discuss his options with him. And to this.
Are these the only things holding him?
Your Honor, if we can make a minor request, he's currently awaiting an MDOC tether for a circuit court case that he's on probation for a home confinement tether. He saw the visiting judge for Judge Conlon yesterday. He turned himself into the jail yesterday morning on that warrant, got that violation taken care of. They granted him the PR with the MDOC tether with home confinement. So we would be asking if the court would consider removing his tether for his bond on the CCW case, considering he'll already be monitored with the MDOC tether.
But we won't get that information.
And that's what I was explaining to him, Your Honor. We just would make that request because it does seem a little redundant that he's going to be home confined twice.
And Your Honor, if I may add, Mr. Macowski Smith has been very communicative with me on during my co-server's representation. As soon as he was instructed to turn himself in, he called me immediately to let me know what he was doing and that he was about to turn himself in. So he's been very communicative, and I've every confidence that the court will be able to.
He's got 2 legs, so we can put a tether on each one.
Understood.
Is that right? I mean, I'm just saying.
That's what it have to be. That's what it have to be, Your Honor.
And understood, Your Honor. I did have that conversation with him as well.
If we can get communication from MDOC, I don't mind releasing ours, but I'm not going to release our tether until I have that assurance that we'd have the information.
Understood, Your Honor. We can see if that is a possibility.
All right, so that request regarding modification of bond at this time is denied, but if they get that information, then we'll figure it out. Okay? Thank you. Oh, it's the 18th.
Thank you, Your Honor.
Court calls case People versus Dominic.
Trevor Maybell for the people, Your Honor.
And with that, just on behalf of Mr. Brewer, who is here with me, can you please say your name for the record?
Dominic Brewer. Thank you.
Your Honor, we're asking for a 3-week adjournment so we can continue plea negotiations.
3 weeks?
Yes, if Your Honor is so inclined.
3 weeks?
Oh.
Why?
Because I'm on vacation and he has requested that.
So we all have to wait for you to get back?
No, I can do my work before my vacation.
You're gonna do it before the vacation, then why am I giving 3 weeks?
Because it's unrealistic that I complete what I need to do for his case before my vacation starts. Your Honor, I have full faith in my PD team that if it gets adjourned 2 weeks, that they'll do even better than I would on his case. But I'm just trying to get
that's
his
sweet.
request in. Yeah.
I know where she.
Do a bench conference.
September 25th, 2025, 90. Bond continued.
Thank you, Your Honor.
Thanks. Take care. Okay. Court does call the case People versus Megan Moses.
Lauren Brown, Deputy Chief Public Defender, appearing with and on behalf of Ms. Moses, who approaches to my right. Ms. Moses, please state your name for the record.
Megan Moses.
Your Honor, today is the date time set for probable cause conference.
It is.
At this time, there was an agreement in place. So we're going to be asking for an adjournment of this probable cause conference and some consideration on bond later on.
Okay. How much time did you need?
Let's start with 3 weeks for the adjournment.
Okay.
All right. We're going to go into the bond.
Yes, go ahead.
So, Ms. Moses, I believe she was here last week. She had turned herself in. She had issues both with her tether, being able to get a Zoom date. When she appeared here, there was a question about whether or not she had communicated with our office or with anyone concerning the issues she was having. The attorney who was standing in at the time, I don't think was able to let the court know that Ms. Megan had in fact been in contact. She did let us know. She did let us know that she had issues. We have file information from August 20th where she contacted us concerning the issues she was having concerning her phone and her tether. So I understand that one of the things that the court was concerned about was that she did not have communication with us. And that's just not the case. She did have communication with office. There are file notes that indicate that she did contact her office. More importantly, she did turn herself in. She came into her court date. She was here. She was present. So what we're asking is that not only that she be released from jail during this interim period, because part of what we're trying to do is to get her in a situation where she can pay restitution for this matter, without giving away too much. So we want to be able to get her out, get her employed, and get her to making payments. And so that comes to the second part of what we're here to ask.
What day did she turn herself in?
Last Thursday.
Last Thursday. And she came here, she came to court and then she was taken into custody. She was remanded when she came to court. So she came here.
With the tethers.
Okay. Because I think I did address most of that yesterday with the last time that we were here, but response from the people.
Your Honor, ultimately, leave to the court's discretion. I can't say what communication she had with her attorney. Obviously, I'm not privy to that. My concern is I do think that she does need to get in order to make that restitution payment. That is sort of the contingent basis of this plea negotiation. Whatever steps the court feels it needs to take in order to monitor her. I have no objection to that, but I think that some form of release might be appropriate, given that we need to have that payment, because you can't do that in custody.
Right, but the problem that I'm having is typically one of the forms of doing that is to put somebody in a tether.
Right.
Somewhere she's had a problem with the tether. I don't have any information that the tether was defective in any way. She said there was something with her bike.
Yeah, she was on the bike and somehow
and the other problem is that I'll say maybe she misspoke, but regarding the communication and where she was vis-a-vis her mother when she was last here, because she said one thing and then switched that and said another. That was another issue that I had with the story she was telling me.
So I wasn't here, so I'm not privy to what that was about.
So what she said is she initially said she called her mom. However, prior to that, it indicated that her phone was broken. And so that she couldn't call. Then she abruptly changed and said she rode her bike to her mom's.
So what she's telling me is that she did call her mother after the phone was broken, but she did that at a gas station. She had to ride someplace.
Where?
At a gas station.
It was a Walgreens, actually.
Walgreens gas station. So she had to go someplace.
So last time the story was told, we didn't have a stop at Walgreens.
It was a lot going on.
Apparently.
The story, and I was nervous. So I was saying I called my mom and then I rode my bike, but it came out as I was misspeaking, but it was all together. I did call my mom and then rode my bike to her work. But it was at a gas station. It wasn't on my cell phone or anything.
Is that a gas station?
It was a gas station.
I thought it was a Walgreens.
Well, there was a Walgreens next to it, but there's a gas station Walgreens. It was like right there in Jackson on West Ave.
Didn't she just tell me she called from Walgreens?
It was a gas station Walgreens, like right there. Honestly, it was the Walgreens phone that I used.
At the gas station?
No, there's a gas station next to it. So they're both, it's the same building.
Should we Google Mr. Jackson?
I'm not Googling anything. But
I'm just saying that's where I stopped to call my mother.
Okay, so here's what I'm going to do, because I either you have a problem telling a story,
I'm not,
or you're not telling me the truth. So what I'm going to do is I will adjourn this 3 weeks, and that is to September 25th, 2025, 9 a.m. At this moment, I will have her bond continue. You've got a lot of people, Mr. Brown. So if somebody can show me a building where there's a gas station attached to a Walgreens that she's in that area,
They're not
I will then,
attached.
they're not attached.
No.
Of course not, they're not.
We
Oh
will
my
Google it and we will have a picture sent right away to the court.
If you show me something that makes this story make sense, because this is now an added piece. He's at a drugstore calling, who are you looking for? Who's gonna have to do it?
Oh, I'm gonna get one of our fine fellows.
I know, but which one? So that when it doesn't happen.
It was West Ave.
Oh, you guys get paid too much to do this. No.
It could have been a CVS. Honestly, I was-
Shanaza, you can't even appear for your case and now you're all in this. What? It's not it's a CVS? So it's not even a Walgreens.
I was in there was a lot going on, honestly.
I know.
I was in a panic, so I can't remember even where I called from. I'm pretty sure it was the Walgreens or CVS.
Okay, we're not gonna sit out here while you look at the computer. I've made my order. They can then, what?
CVS right there, I think. Thank you.
Show it to the prosecutor. Is it a Walgreens or is it a CVS? She doesn't even know what drugstore she's in.
Wait. This is not Jackson.
That's not where it
That's
is.
not even Jackson.
Yeah, I know.
Jackson, Michigan.
Right? They were gonna show me some fake Google pictures.
No.
No, I know what was gonna happen. Okay, I don't. All right, I've made my ruling. You guys can show this to me. She'll get released if I get a picture of the real place.
We got you, Judge. We're on it.
No AI, none of that, Mr. Brown. I know you don't even know what that is, so I'm not even, but I'm worried about them. Don't, Shanaza, get out of this case. What are you doing?
I'm looking at my case, Judge.
We got you, Shanaza.
Indians. Thank you.
Whoa. This is. Where's the gas? This is the gas station? That's they're not attached. There's a road in between.
My
like a big road.
My client is not as eloquent as you, Your Honor, when it comes to describing things. Now we could get her some writing classes so she can learn to paint word pictures, but it is on West.
Hold on a moment. No. You're a very good attorney. You are not going to spin this. She told me the Walgreens, and it's not a Walgreens, it's a CVS.
I mean, she did say it was possibly a CVS, though.
One's red, one's green. She said the gas station was attached to the Walgreens.
Well,
there's a road.
Maybe it just got built.
No, there's a road.
Is it a newly paved road, Your Honor? It's a brand new road.
Here, no, I'm not recalling it. You can let your client know. I did look at the map.
Yes.
Story still doesn't make sense. Her motion for bond reduction still denied.
Thank you.
But thank you for the pictures.
Thank you.
I don't know who it is.
Oh.
Can you ask who it's?
There's an individual from MDOC, the Women's Huron Valley. Can you state what your name is? I think she's frozen. Appears to be who?
Miss Johnson. Valerie Johnson.
Okay. So court does call the case People versus Valerie Johnson.
Again, Your Honor, people.
This is public defender Hannah Apple hearing on behalf of Ms. Johnson. Ms. Johnson, will you state your name again for the record?
Valerie Johnson.
Thank you.
All right, I do have a plea form in front of me where she's gonna plead to the charge, count 2 of use of a controlled substance, a 1-year offense. Upon her successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's correct, Your Honor.
That is correct, Judge. And for the record, I did speak with Ms. Johnson this week. I did review the advice of rights form with her. She did give me permission to sign that as well as the plea form on her behalf.
All right, thank you. Johnson, can you raise your right hand, please?
Yes.
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again for the record, please.
Valerie Johnson.
Okay, you can put your hand down. Ms. Johnson, it's this court's understanding that you're going to plead guilty to the charge of use of a controlled substance. That's a misdemeanor punishable by up to 1 year incarceration or $1,000 fine plus court costs. You understand that?
Yes.
All right. Still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form or went through that and gave your attorney permission. Is that correct?
Correct.
Did you have any questions regarding any of the rights on that form?
No.
Under paragraph 5, those are your trial rights. You understand that you'll be giving up those rights as well as all the rights that are contained on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
You on probation or parole? You're not.
No.
You're incarcerated. All right. Has anybody promised you anything other than what's been stated here today to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of September 26, 2023, at the Huron Valley Correctional Facility, did you have fentanyl in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
No, I thought it was heroin.
Okay, you thought it was some other drug. You thought it was
Yes.
heroin, but it was
Yes.
fentanyl. Is that correct?
Yes.
Okay. I think either way. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Ma'am, is there anything you want to say before I do impose sentence?
Your Honor, if I
No.
may speak on Ms. Johnson's behalf?
Sure.
Your Honor, I did have a chance to speak with Ms. Johnson. This offense happened 2 years ago. At the time, she was grieving the loss of her mother, was unable to attend her mother's funeral. Since then, she has enrolled in treatment in the Michigan Department of Corrections and is currently on a MAP program. She does have her earliest parole date is not till 2033. So I'd ask the court to impose minimum fines and costs.
I'll impose $125 state fee, 365 days in jail, credit 365, sir. Thank you.
Thank you, Your Honor.
Good luck to you, Ms. Johnson.
Thank you.
Court does call the case, People versus Dale Miller.
We're ready in that matter, Your Honor. Vaughn Brown, Deputy Chief Public Defender, appearing on behalf of Mr. Miller, who appears by video. Mr. Miller, could you please state your name for the record?
Dale Joseph Miller, the Alpha and Omega.
Okay.
Your Honor, the reason we are here today is this was set for a probable cause conference. However, Mr. Miller is undergoing competency evaluation and other matters.
What? No, go ahead.
So we
Oh,
can
you
go.
guys can find out it's not
I'm
so
in-
funny pretty soon.
I am informed of that. And we have, is there a competency order for this file?
Yes,
Yes, I do have it. All right, so what I will do
On
is
top
I
of
will
things.
order competency on this file. I will set it, I think those are set for November sixth.
Yes, so we'd ask Mr. Miller, just as we spoke, we're gonna ask that this matter be joined with the other matters.
So I will set this for November sixth, 2005, 9 a.m. This time as bond will continue. Thank you.
Thank you very much. Your Honor.
I would have done the AI, Mr. Brown. Court calls the case People versus Montes Miller.
Assistant Public Defender Jay Bellinger on behalf of Mr. Miller on case ending in 1435, Your Honor.
And Edward Lucas on behalf of Montes Miller in 1434.
You both are requested. And your name, sir?
Montes Miller.
Thank you.
Your Honor, I did be put before the court an order for release to treatment. I'm hoping that the court will sign that so that he can find a bed as soon as one becomes available. Otherwise, we don't have any discovery on this case, so we'd be asking for an adjournment.
I'm just asking for an adjournment for video purpose.
Get these together. Is this the only thing holding him?
I think there's some nominal bonds in these two cases. I think there is a circuit court case that
He's got a violation up in circuit.
Got it.
Sir.
Probable cause conference, September 25th, 2025, 9 a.m. Bond will continue.
And Your Honor, as to the order for release to treatment.
Oh, I'll sign the one that Mr. Drukas. I'm not signing. No, I'm kidding. I signed them.
Thank you.
Appreciate it, Your Honor.
Thank you.
All right. Thank you, sir.
Okay.
I want everybody to drive around and I will call somebody's cases. I'll give somebody a reward. Whether it's a pharmacy hooked to a gas station. If somebody shows me one of those, I'm just thinking. Those seem like two incompatible uses, but maybe I'm wrong. Court does call the case of People versus Tiffany Cash.
Assistant Public Defender Alexis serves with an on behalf of Ms. Cash, who should be present via Zoom.
Bless you. Ms. Cash.
Perhaps she got up to use the restroom, Your Honor. Ms. Cash, can you please unmute and state your name for the record?
Think she can hear you in the restroom or what?
Your Honor, may we briefly pass this?
You enacted early. You're pushing it. Court does call the case People versus Justin Strait. And I've got a DOC.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Strait, who approached. Mr. Strait, can you please state your name for the record?
Justin Strait.
And Your Honor, I am asking for an adjournment. Although we are now in receipt of the media discovery, I have not had time to go over that with my client. However, I do understand that the court did sign an order for release to treatment over the last few days.
Yes.
Please.
He did. Okay. So they have it already. So they're good. Okay.
So I can get in?
Yep.
Thank you.
Got it. Very good.
So this is the only thing holding, well, he's got a bond violation on this one, but this is the only thing holding him.
As far as I know, Your Honor.
Probable cause conference, September 25th, 2025.
Should be in it. Usually 9:25.
Bond
Should be in
continue.
bed by then. Okay.
Thank you.
9:25. Should be in it.
Court does call the case People versus Anthony Alfaro Callejas.
Good afternoon, Your Honor. Attorney Zach Bonham. My client is there in the courtroom.
Good afternoon, Your Honor. My name is Anthony Callejas.
We have not addressed this.
We have not because.
Got it. Okay. All right. All right, what are we doing on this?
Your Honor, I would ask for a short adjournment. We have some ongoing negotiations toward a resolution. There is a minor issue with some discovery that I assume are going to be taken care of very quickly. So we just need a short adjournment.
Have you received the bond violation report, Counsel?
I have, Your Honor.
You have?
Yes, I did. I received it last night from your office.
Okay. This is probably more of a problem, Mr. Allen. Does he wish a hearing on this? I mean, I've got August 14th, he's positive for alcohol with the high being a 0.07. And then on the 20th, he is also positive for alcohol at a 0.06, being the high, and then failure to take his retest on that. He's just missing tests all over the place, not testing timely, but then not retesting. And then on August 29th, he's positive for alcohol at a 0.031, and then missed retest early into the morning or early into the evening. Anything you'd like to say on that? Because
Yes.
I see this. Go ahead, sir.
I appreciate that, Your Honor. What I'd like to point out is that he is also on a GPS tether. He's had no violations on that GPS tether since that was put on January or July 25th. He has had some late testing. If you look at the throughout the bond violation report, there's many instances where he's maybe 10 minutes late for a test, but he still tests and he's negative for alcohol. There's a couple where he's an hour or two late, but he tests negative for alcohol. And that's the most common offense that we see throughout there. My client tells me that when he was given the alcohol testing device, that it wasn't, explained to him regarding the test. He's also had problems with the test actually working. And I emailed over to your office, and hopefully you have a copy of it. I know it went to the prosecutor's office as well, but it was a copy of the notice from the device saying that it was overheating and it's not able to work. That's part of the problems that he was having. He's reached out to community corrections to ask for advice on what to do when he's having these problems. He never received a return call from them. When my client reached out to me, or I reached out to him after with this alcohol reports, he's adamant that he has not consumed any alcohol, but he had used mouthwash that contained alcohol in it. I advised him that that could cause a problem, as well with his medical issues. It could exacerbate that problem and provide a false positive test, which he's saying is what's happening with him. Once I advised my client about this, since it would have been the end of last week when I first found out about it, he hasn't had any negative tests since then. He also had an issue with the charger with those devices. He had to go get another charger so he'd keep that. So I know on paper it looks like he has a lot of violations, but it's a lot of the times where he's a little bit late for a test, retest, and he's negative. So what I'd ask is that we would continue on with the testing. He's taking care of the issues that he's had with that. I believe I just got a message from your office saying that they are printing that now. It was the image.
I have.
Okay, all right, great. So that's something my client sent to me. That's what the readings he would get, and that would be part of the problems of why he had these, late tests in some of these instances. So other than that, he hasn't had any other problems. He's got employment. He's got another job that's upcoming. He's just got a new apartment, which would be part of our motion to amend the bond. So we just ask that you keep him on the home confinement.
Okay, well, two things, and certainly I'll let the people respond. But with reference to the bond violations, even if he consume, first of all, that's a lot of mouthwash. Number one. Secondly, if the mouthwash contained alcohol, he is apprised at the very beginning when he signs up for the SoberLink device that he is to consume not only just not drink, but he is to not use any products that contain alcohol. So if it is mouthwash, and I'll be honest with you, I don't believe for one darn moment that it is. I think that's a bunch of malarkey, not the word I really want to use. And if he wants a hearing, we'll have a hearing.
I have a hearing.
Pardon?
Oh, sorry, you say hearing?
There'd be a hearing on it. I'd set a hearing on this. We'll have a hearing. We'll bring the experts in. We'll bring everybody in regarding this testing.
Okay.
And this problem that he's having, the device, the temperature of the device is too high. It's not necessarily a malfunction of the device. It's something else that he's doing with regard to that machine. So, counsel, do you want a hearing?
We can set a hearing, Your Honor. I believe that's what my client wants to do.
Well, it's just gonna be a longer day, but what the heck. I'll adjourn the probable cause conference on this to next week, the 11th, 2025. I set it at 9/8. Well, actually, I might as well just set it at 3 p.m. if I'm gonna have a hearing, and a hearing on the bond violation. But at this time, and I really don't need to hear from the people unless you want to tell me something. On the case ending in 1167, I will continue his bond on that case. In the case ending in 5152, the operating while intoxicated, defendant's bond at this time is revoked pending hearing. Defendant's remanded.
Thank you, Your Honor.
Thank you. The court calls the case of the people versus James Young.
Judge, I'm Barton Morris. I'm appearing on behalf with the defendant.
All right.
There's an amended information.
Yes, could you state your name, sir? There is an amended information regarding counts 3 and 4. Count 3 being child sexually abusive material, aggravated possession, and then count 4, computers using a crime to permit with the maximum imprisonment of 10 years or more, but less than 20.
We've received the amended complaint, and I would stand my client mute regarding payment.
Pending mute, court will enter a not guilty plea. All right, you're requesting an adjournment for additional discovery.
Correct. As there are new charges, there's additional, obviously, discovery, and the people need additional time to get that to us. They're continuing their investigation. And we've agreed, if it pleases the court, to October 2nd or October 8th.
And that is correct.
Neither one of those. I won't be here October 2nd. The 8th, not a Thursday. I mean the 9th. Oh, will that work? That's okay. I did that earlier and got yelled at. Okay, she didn't yell. Felt like I was yelled at. Forever Cause Conference will be adjourned October 9th, 2025.
And
9 a.m. Yes, sir.
we've agreed that the bond conditions shall remain the same.
Your Honor, I did just want to say for the record that in reference to discovery in this case, so Detective Sergeant Mike Matthews yesterday, there are over 6 million images that we should go through in this case, so I'm not sure exactly when that is going to happen. Throughout the penance. They did
6 million?
6 million, they do 1,000 every 5 minutes, it's still gonna be quite.
I'm not doing the math. Okay, I'll just take your word for it. All right, well, we'll figure it out, and if it's not near ready, contact my office if we need an additional date or something like that.
Thank
All
you.
right? Thank you. Bond will continue. Yes, court recalls case of People versus Thompson.
Good afternoon, again, Your Honor, Raymond Cook, please.
And again, Assistant Public Defender Jay Bellinger on behalf of Ms. Thompson. Ms. Thompson, can you please state your name for the record?
Joanne Thompson, sir.
All right, we got her test back. She's all negative.
I've been trying. I'm really trying right now. I'm trying to get my life together for my kids with losing my spouse the way I did. I'm really trying. I know I messed up and I'm not afraid of it. I'm sorry I messed up, but I'm really trying right now.
Well, part of the other reason I gave you that opportunity is because Mr. Bellinger convinced me to do so. Because normally I have a very swift way in which I deal with it, but you thank him, don't thank me.
Thank you. I appreciate it more than you will ever know.
Okay, and you're requesting an adjournment on this?
Yes, Your Honor. My understanding as Ms. Thompson previously stated is that she's got the intake for Don Farm's outpatient program on the 10th. So I would be asking for 3-4 weeks after that so we can monitor her progress.
That objection, I'll adjourn this to October 9th,
My birthday.
2025, 9 a.m. Okay?
So hopefully good news.
You said 9 a.m.
Well, I'm not sure.
It'll probably be
Just
late.
call just to be sure.
Well, you can either call the court or your counsel will let you know what time you're set.
Okay, yeah, because I happened to yesterday morning. I called. They were like 9 a.m. and then I got a call later evening, like 2 p.m. I'm like, oh, okay.
I didn't answer the phone, right?
No, you did
So
not.
I can't tell you what happened.
Okay, thank you,
All
Your
right.
Honor.
Thank you.
Thank you. You have a good one.
You do the same. Hey, how many cases do I have?
There are 6 total.
All right, folks, I'm a little bit late on my 4 p.m. I gotta take a brief break. I gotta make a quick phone call, hopefully quick, and then I'll come back. Oh, no. When did he get here? Court of Seniors, I mean, Bert snuck in here. Court does call the case of People versus Devonte Owens.
Good afternoon, Your Honor. Ashley Feltes for the people.
And Jonathan Emmons as well, Your Honor. Thank you.
Good afternoon, Your Honor. Please disarm the court, Brandon Bird on behalf of Devonte Owens. Mr. Owens, can you please state your full name for the record?
Devonte Owens.
Fine.
Your Honor, today Defense Counsel emailed Mr. Evans and myself a motion and some proposed orders. I am going to request on behalf of the prosecution the full 7 days to respond to those motions, that motion, excuse me, and I understand there may be more coming.
More
Motions. Mr. Bird and I discussed where this case is headed, and we are set for probable cause conference next week after the arraignment today, but that date likely will not be enough time for all of these things to happen.
So you're potentially objecting to a subpoena dicus secum to a company?
Yes, Your Honor.
On what grounds?
Your Honor, first of all, I didn't have all the time to review this because
I understand
today. MCR 6.001 for scope specifically says that depositions and other discovery proceedings under subchapter 2.300 may not be taken for the purposes of discovery governed by cases governed by this chapter.
There is no subpoena ducis tecum provision in the court rules other than Court Rule 2.305, which is prohibited by the criminal discovery rules. He cited to 6.5, but that's for post-appellate relief.
You're objecting to his ability to serve a subpoena for discoverable, what could be potentially discoverable and exculpatory information?
Potentially, Your Honor, we would like time to respond in writing.
Okay, yeah, you have time to respond in writing. And if you're correct in that, then I'm going to order the people to produce it, if that's your witness.
Okay, Your Honor, I have
So
not.
that you understand where I will head.
Thank
The
you.
information will be gotten one way or another.
Thank you, Your Honor.
And thank you, Your Honor. Respectfully,
So I'll adjourn the motion out. When are you set for PCC?
respectfully, we could set this for PCC for October 25th. I know that's pretty.
October 25th?
September 25th. Sorry. September
If you
25th.
said, if you were serious on October, I was going to come off the bench and tackle you. It was just my visceral response was going to be that.
I was a defensive tackle. It's not
I
gonna
just
be.
wanted, I just
not
wanted
gonna
to
be.
make sure what I was hearing.
But if we could set this for September 25th, I do plan on putting in some more motions. This is a lot of discovery in this matter, and before I make any decisions on how we proceed further, I need to speak to my client multiple times and go through every inch of that discovery and put in every motion that I need.
All right. So what I will do is I will adjourn this to September 25th, 2025. And I'm going to make it at 3 p.m. and I'll adjourn also your motion to that time.
Thank you, Your Honor.
Will the court conduct the arraignment as to the added counts today?
I will.
Thank you, Your Honor.
You got a copy of the information on this, the new amended complaint?
Yes.
Mr. Burns?
I do got a copy and was able to go over it with my client also, Your Honor.
All right. And as to those counts, does he waive formal reading stand mute to the added counts 3 and 4?
Yes, yes.
3, 4, 5, 6, and 7.
Yes, Your Honor.
And I don't know if I said this, he stands mute to those charges, correct?
Correct, Your Honor.
Court will enter a not guilty plea as to those counts on the defendant's behalf. Counts 3 through 7. Did mute to those counts. All right, so we'll adjourn that off. The defendant's bond, is it currently stand at denied?
I think it's currently $750,000 cash, Your Honor.
He's not previously charged with the count 4.
My client.
Then in regard to bond.
No, nothing regards to bond to me, Your Honor.
All right. The court, given that the new charge of homicide over murder is added, the court at this time is going to deny the defendant's bond.
Thank you, Your Honor.
Doing that pursuant to the court rule.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Court does call the case of People versus Adonis Sweat.
Ashley Feltus for the people.
Again, Jonathan Evans on behalf of the people as well.
Good afternoon, Your Honor. Wendy Barnwell, P42 505 on behalf of Mr. Adonis Sweat.
Your name, sir?
Adonis Sweat.
All right. Let's do this as to the additional charges, the arraignment on those. Do you waive formal reading of the charges, counts 4 through 7?
Yes, Judge.
All right. And your client stands mute to those charges?
He does.
All right. Court will enter a not guilty plea on his behalf. 4 through 7. Stood mute. All right. What are we doing with this case?
And I know that we have a PCC on September 11th. And as counsel said, the co-counsel said, I don't know. I mean, I have a bunch of discovery and more to be gotten because I have to take down an independent device because there's so much memory that needs to, they can't send it the normal way through evidence.com. So I'll ask you the
So-
September 25th date in the morning.
Just to keep them together, Your Honor.
I will adjourn probable, well, I'll have to do it in the afternoon because I've got motions coming up, council.
Okay.
I
So
don't
that
know if
would
you're
mean
jo-
that
I
September
don't know if-
11th is off?
Yes, I'll cancel the September 11th, move it to September 25th. I don't know whether or not you're joining in the co-council's motions or not.
Haven't seen a single motion. Nobody has served me with a copy.
I'm sure they'll all be happy to send those to you. So I will
Thank you.
cancel the September 11th PCC. I will now set it for September 25th, 2025 at 3 p.m. All right. Given anything regarding bond, the court is inclined to deny the defendant's bond at this time with the added count 4 of homicide. Anything you wish to say, Ms. Barlow?
No, Judge, I'll address it on September 25th. Thank you.
So at this time, defendant's bond is ordered denied pursuant to the court rule. Anything further?
No, Your Honor, thank you.
All right, thank you.
Well, that's where we'll leave Washtenaw County and Judge Simpson for now. We're in Burnett County, Wisconsin with Judge Mogan, who has a very serious sentencing related to a violation of protection orders.
All right, we will go on the record in the matters 24 TR 112, 25 CM 30, 25 CM 125, County of Burnett, State of Wisconsin versus Victoria Mott. The state appears through District Attorney Kevin Schmidt in person. Ms. Mott appears in person with counsel Joel Valiski. We're set today in this matter for the sentencing part of this case. We did have Ms. Mott here on August 14th, in which she pled guilty to violating a harassment injunction times 3 counts. We have 2 victim impact statements to hear today. We will move forward and hear those. However, I did just get a recent filing as of today from Ms. Mott in this case. I wanted to ensure that Mr. Schmidt had an opportunity to review that.
I did.
All right, I did as well. Although it is very difficult, just saying on the record, very difficult to get filings on the day of sentencings, especially when it's multiple pages. It's very hard to find time to read. All right, so Ms. Bauer, we have 2 victim impact statements. One may come at a time and sit at that black desk. You can state your full name for the record or your initials, whatever you prefer. And if you're going to read something, please read it slowly so that my court reporter can take it all down accurately, okay?
Christy Haskins.
Can you please make sure that the microphone comes down to you? Thank you. Okay.
Christy Haskins. Is that better?
Is that even working? Can you hit on the top of the microphone?
That's not working.
Oh, is it working?
No, it's red.
I think red's fine. Just tap on the tap. Or tap on the top. Yeah, it is working. So just bring it a little bit closer. You didn't get a new one for there apparently. All right. Okay. You may begin. And it's Christy, K-R-I-S-T-Y.
Correct.
Okay. Thank you.
Your Honor, thank you for allowing me to speak today.
And I'm hearing already that it sounds emotional or like it has emotion. And so I'm going to just let you know if you need time to stop, I'd rather you stop take a breath, take as long as you need to compose yourself, because again, it gets difficult for my court reporter to understand.
I'm requesting that Victoria Mott gets full punishment for all violations she incurred. It's been proven that Victoria cannot accept any implications as she is not seeing the consequences in her actions. She repeatedly violates the restraining order against her, and yet nothing has deterred her from the fear or constant harassment she has put on this family. While we have been on this constant merry-go-round for the last several years with Victoria, we're hopeful that today, sentencing, that Victoria will finally see the hurt she has caused our family. My husband and myself, along with our entire family, had to deal with her showing up randomly whenever she feels like damaging property, also almost running over my husband on the property. Driving over our septic system, doing donuts in our yard. The constant fear of vandalism, physical violence that she had incurred on me. This is all we've endured is not easy to be explainable. Our family should feel safe in our home. It should not feel that our property can be damaged at any time of the day. Your Honor, we ask for peace. We would like to also request an extension on our restraining order for the maximum allowed or per your discretion. We truly hope that Victoria has time to reflect on what she has damaged, what she has done. We have both, me and my husband, have traveled many times back and forth from here to other properties that we had, leaving work, spending several days at the property on numerous occasions because we did not feel that it would be safe if we were not there, even with the security cameras that we put up. The defendant has proven her inability to acknowledge or to stop showing up. She continues to be there, even after, like right after we were in court. So I urge you to honestly sentence her to maximum penalty. No one should have to do this. No one should have to live like this. Not for just my sake, my husband's sake, my grandkids, and even my kids that are underage. We can't enjoy the property or properties around the area because of this. How would you like it if you're laying on your couch sleeping in the middle of the night and she drives around your property recklessly, screaming profanity outside the window? This is not one time. This is several times. She has not stopped. And I don't think she will until you honestly make her pay for what she's done. So I thank you for allowing me to speak.
Thank you, Ms. Haskins. I do have to address one thing. You did ask for an extension of your restraining orders. This is not the proper venue to ask for that. And plus, they are through 2027, so there's plenty of time to look and assess before you were to ask for something like that. But in the criminal case, I cannot go to the civil matter and adjust that. Okay, just letting you know that part.
Thank you.
All right, thank you. Mr. Haskins?
My name is Jason Haskins, and I am Miss Christy Haskins' husband. A lot of the stuff overlaps. Do you want me to go through it all again?
You may. This is your time to let me know what you want me to know.
So basically, starting on July 14th, 23, there was traumatic episodes with Miss Mott, and basically on our property, continually telling me how she's an independent woman. She doesn't need help. Very violent, always violent towards my wife, more so than I. Going forward, that's not the property on County Road A. We spent the money on an ADT system with 5 cameras. The cameras seemed to always be in the position that didn't catch her, meaning she would go in the bottom door, the back door, slide in a bedroom window, however it may be. And I witnessed this once. I was in the bedroom where she thought my son would be because I had back surgery. So I was laying on his bed and I could hear a knock at the window. And my 16-year-old son had just gotten a newer used vehicle, which she did not recognize. So she's screaming through the window, "Who's in there? Who's in there?" And my son and I both woke up like, what just happened? Went outside. That is when she was driving erratically up and down the driveway at a high rate of speed. Stopped just 2 feet short of hitting me because I was not very bright. I stood right in the driveway with my hands on my hips, like, what are you doing? Didn't even let up till 2 feet and then finally stopped. Eyes were wide open. So whatever that indicates, I don't know, but wide open. So that was that instance. Basically, I agree with my wife. I don't feel safe going up there. She has many friends that have come on our property. Matter of fact, I confronted one of them, which JJ Lehman is the gentleman's name, and asked him why he was there. And he explained he was there for Tori. And I said, I don't want you on my property. I think right now you're trespassing. Let's call Burnett County and get them coming. Well. So we got in the argument, and his girlfriend thankfully convinced him to leave. So we didn't have an altercation, but again, another fine instance of something that we're, I don't know, I own a property and I can't even use my property. My son lives on the property, and whether she shows up whenever, however, it should not happen. We have the restraining order, and it's, I swear to God, it's almost like it's a challenge. She comes there more now. So, and currently now her stuff's stored at the house, her dog's at the house, and her kids come and stay at the house. Now, I don't understand why. And due to the previous altercation she had with my son, I don't know why you would keep showing up there with all of your stuff. But anyway, that's where we're at with that. I probably, Your Honor, went up there from Hudson, Wisconsin, no less than 2 days a week for almost a year, just to deter this. Didn't stop her. As a matter of fact, she bragged to me that she was at the house when I was sleeping there at the house because I was downstairs. So I don't know what it's going to take, whether it's, jail time, whether it's taking care of the damages she's done, however it may be, it needs to happen. Previously in her life, she's gotten out of pretty much everything with a slap on the hand and just don't do it. And I don't think she's learned anything. So, I don't know if I'm really missing anything here. It basically just comes down to that. And before all this started, I tried to talk to her and help her through things. And then after I'm a strong, independent woman and I don't need help. Okay, well, you're not getting my help. So, and I guess the only thing I would like to say in reference to Tori, and hopefully she's paying attention, is spend more time taking care of your children, having a consistent job, not drinking, not doing other things, and you would be a much better person. And I think that's where we're at with all this. I don't know what else to say or do that would sway you any other way as far as what she could do to get better, to get back on track. So I guess that's it, Your Honor.
Thank you, Mr. Haskins. You can go to the seat. Thank you. All right. Mr. Schmidt, argument and sentencing recommendation, please.
So I'm going to go back a ways because I think there's some important historical context for the court to understand why we are where we are now, as well as to give some context to the letter that Mott wrote to the court earlier, which I imagine was pretty confusing for the court if it didn't know the history.
It's not. For the record, I'm very familiar. This goes way back to, I believe, 2022 with Jordan Haskins and criminal charges. And then there was an injunction. And then quite honestly, I have had cases involving the Haskins in Washburn County. I've had cases involving Ms. Mott and the Haskins in Burnett County. I'm well aware, and I was just going to say when you're done, I'm taking judicial notice of the 22 CF46 case with Jordan Haskins, as well as the other matters involving Mr. and Mrs. Haskins and Ms. Mott. But please, for the record, argue all that you're intending on arguing. I just wanted everybody to be aware. I have a really good memory and I recall the facts.
Sure. I'm actually starting in 2016.
2016.
2016.
Could go back to there, but I don't recall off the top of my head what happened in 2016.
You won't because there's no case associated with it.
Then I wouldn't be aware of that.
No, I'm going to be talking about law enforcement things too you wouldn't be aware of. In 2016 is when Jordan Haskins with his then significant other, Courtney Strunk at the time, purchased the property we're talking about here. They lived together until in 2021, the property was quitclaimed entirely to Jordan. They eventually split up. 2021 is also the first time we had a domestic case with Miss Mott and Mr. Haskins. It was a domestic DC and battery. Because of his limited history, it resolved as just an ordinance in this court. Another incident happened that was more serious in 2022. Victoria was still residing with Mr. Haskins. Without bothering to go into the facts, because I don't think that's necessary, it eventually resolved with Mr. Haskins entering a plea to a domestic battery and a strangulation. He went on deferred agreement with the strangulation. He went on probation for the battery. The strangulation DJOC actually ends in like a little under a month. The term of probation already ended because it was probation on one misdemeanor. During the course of the case, as many domestic abuse victims try to do, Victoria Mott tried to recant her statement. Because we had body cam already back then, we pursued it anyways because her statement on the body cam at the time of the incident was so compelling and Mr. Haskins was so incriminating. During the course, they both did the CRA class to start contact before the case even concluded. When he was placed on probation, DOC, regardless of what the court orders for contact or no contact, can always do their own thing, what they think is safe. And when they have a domestic battery probation with a person also under the plea to strangulation, they chose to do just no contact at the start until, hey, lay off the training wheels later. During the course of that probation, Jordan did continue to have contact with Victoria, and he served some jail time for it during the course of that. About a year and a half into that, Jordan transferred the property to his parents on a quitclaim, saying no consideration. 2 days later, all three of them, his parents and Jordan, filed for restraining orders. Jordan would abandon his restraining order. Well, Christy and Jason would get their restraining orders. That's the restraining order we're saying is violated here. This restraining order is a little unique in that it doesn't just prohibit contact at residences. It names specific addresses regardless of whether they're your residence or not. And this is one of those addresses. Regardless, Jordan Haskins has continued to have a relationship with Victoria Mott, as evidenced by, there have been many other of these reports, these referrals of these violation restraining order that we never charged because they were essentially Jordan admitting that she was there on his behest, or Jordan asking, is there anything I can do to end my parents' restraining order? He's continued to live at the same property continuously, even after he gave it to his parents. He seems to have continuously lived there for almost 10 years now. Part of what I think the victims have alluded to, Mott avoiding camera footage so successfully, that's how. He obviously knows where all the cameras are. He can aid her in avoiding those. Regardless, when we got the first spat of those referrals for that kind of restraining order, they weren't as severe. We actually met my office with Victoria Mott back then in terms of her being the victim of the past domestic abuse case, and explained to her, Christy and Jason Haskins have nothing to do with your domestic abuse case. This restraining order through the full faith and credit clause, if you violate it by going to this property, because it says go to the property, even if you have Jordan's permission, is a violation, and warned her if she continued to do it, we would be filing cases. She continued to do it. We filed these cases. The behavior got more and more specific and targeted towards the victims, Christy and Jason Haskins. There's really no reason for it at all for her to be doing that, especially when she's continued to have this on again, off again relationship with Jordan throughout the whole time. That is why in this case, Victoria Mott has no criminal history. So normally you'd look at this and say 3 convictions and a recommendation for 30 days jail right off the bat with probation. Is that too severe? No. I think you've heard the impact on the victims back there, how much it's distressed them, how much unpredictability it puts into their enjoyment of their property. And I think it's necessary here because of the repetition. I wanted these 3 convictions to show the repetition, to lay the basis for habitual criminality if it happens again in the future. And I wanted these 3 convictions to show how serious it was. I think the 30 days jail is necessary to show. We know with first-time offenders, the most effective types of incarceration sentences are short ones, because you put them in too long, they create bad contacts, they create bad behaviors, they get new bad friends where they can hang out at bad places with. When you have someone who doesn't have that criminal history, the short-term shock jail sentences, studies show, are most effective. So that's why we're doing 30 days jail there. I think that's the best way to deal with that in this case. I think that the conditions of probation should definitely include something looking at AODA. I can't show in any of these that she was under the influence of anything. I know one of the victims has said she had wide eyes and they think that's involved. The only basis I know for it is the domestic cases we had in the past. She had used alcohol for those. In her statement where she tried to recant the second one, she talked about substance abuse issues. I can't think of any other way to explain her behavior in this case, in these cases with targeting these parents of Jordan Haskins. Nothing else makes sense. There has to be something either deeply related to substance abuse or to mental health. Something is going on there to explain why a person who is (31 years old is suddenly behaving in this manner, this consistently over this period of time. You'll notice with the counts that we charge in this complaint, there's actually a significant period of time that these all occurred across. They weren't 1 week, next week, next week. So for those reasons, I think the probation is necessary. I think the jail is necessary. I hope the court has the full context to get an idea of what sort of issues we're dealing at with Victoria Mott, because she shows evidence of substance abuse, of mental health issues. She herself is a victim of domestic violence. We know she's on again, off again, continuing with that person who has been convicted of doing that to her. There are a lot of complicated issues with her, and I'm hopeful the probation is going to be able to help with that, and the jail is going to be helpful with saying to her, like, these bad behaviors need to be punished. Just because you're traumatized does not give you carte blanche to traumatize others. I know that's something we see constantly in the criminal justice system. I can't think of a single defendant we've had over there who themselves has not been the victim of trauma in the past. I think a lot of people don't know that. So that's what my hope is for this sentence. Thank you.
Thank you. Mr. Felicki?
Thank you, Your Honor. In entering in this plea today, Ms. Mott is paying a price for her actions. She is accepting responsibility for them and is suffering the consequences. I agree with the state in that for someone who has essentially no prior criminal history, that in full honesty, looking strictly from the outside, a year of probation and a 30-day jail sentence may seem severe. I do want to clarify on the record that we are requesting eligibility for ankle monitoring. I understand that Ms. Mott has the funds available for that program. Just wanted to clarify that on the record. But I think that this is an appropriate recommendation of the Galleon factors. Ms. Mott actually was the one who proposed the 30-day jail sanction. I think jail is going to be very appropriate as a deterrent for future behavior, given the nature of this offense, and considering that she will be on probation for a year, she will be further supervised in the community. The community, Your Honor, will be protected from any further violations through this supervision by DOC. And the programming available to Ms. Mott through the department to address any potential mental health, substance use, trauma-related issues will allow her to address her needs. As I've provided in documentation to the court, she has already taken that first step and has reached out for an AODA and subsequent follow-up sessions. She is working forward on moving her life past these incidents, putting distance between herself, between the parties here at issue. She advised in the days leading to this hearing that she actually received an offer for a job out in Lake Elmo, and has considered the possibility of relocating to Minnesota entirely. Lastly, Your Honor, in reference to the letter that she had written and I had submitted to the court, I think what Ms. Mott wants to indicate very clearly to this court is that the relationships that she's had with these individuals have caused her a tremendous, tremendous amount of pain. And I think going forward, her single goal, if she were to only have one, would be to not have any pain anymore. I think that this is an appropriate recommendation, and I would ask the court to follow it. Thank you.
Thank you. Ms. Mott, I do have your written statement that you filed here today, and I have read it, and I have highlighted parts in it, and off the record or on the record, I believe Mr. Schmidt has indicated the state has received that and reviewed that as well. Would you like to make a statement here today in open court?
No, thank you.
The court is going to take judicial notice of 23 CV85 and 23 CV83. That would be the injunction cases with Christy Haskins and Jason Haskins versus Victoria Mott. 22 CF46, because it is relevant and does pertain and has a connection with this case and other cases. The state of Wisconsin versus Jordan Haskins. The court is going to take judicial notice of 22 SC208, and that would be the incident or the case involving Christy and Jason Haskins versus Victoria Mott, the small claims matter. This court has sat on all of those cases. I was the judge on all of those cases, and I have heard for the most part, what was recited by the state in its argument. The court was not completely aware of the relationship in 2016 with Ms. Strunk and how that occurred. However, the other facts, other than any just incidents that were reported to the police, the court was aware of. And this case is something like I can put a timeline with all of the things that have occurred, even though they are different cases. If we had one case separately, this may be less serious and not aggravated, but we have all of these cases that together, in looking at it, which the court can do, and looking at the history, the totality of all of the circumstances, the court can look at that in rendering judgment and making a decision in the case. I have reviewed your statement, Ms. Mott. It is very lengthy. There is no doubt in my mind that you have been a victim. You are a victim. There was domestic violence. There could still be between you and Jordan Haskins. The court was well aware of that back in the 22 SC case, and then having the 22 CF criminal matter with Mr. Haskins. You have been a victim of domestic violence. But in reading your statement, and I'm not going to read it out loud because again, it is very lengthy, but in reading your statement, you feel like you're the only victim. Like it's that you have been the one who is seen, who has been unjust, that the system has been actually harming you and not protecting you. You at no time acknowledge and admit your actions and what you have done.
Towards the end of the letter, I did, and I apologized.
Yes, you apologized, but that's just like a child that gets into trouble, that has a tantrum, that does bad things, that the parent then goes and reprimands, and then the child continues to say, but it's your fault, it's your fault, it's your fault, it's somebody else's fault, it's everybody else's fault. Oh, but I'm sorry, get me out of trouble. Don't punish me so bad. It's not a true apology. It's not a true apology. If you truly felt that you have wronged the Haskins, if you truly took accountability and responsibility for your actions, it wouldn't be 3-4 years later that we're still dealing with the same conduct. I've said this before and I'm going to say it again. Your relationship with Jordan is toxic. It's toxic. And I don't know if it's Jordan. I don't know if it's you. I don't know if it's the both of you. It is toxic. And you say in your letter, I'm very well versed in domestic violence. I represented domestic violence victims for many, many years free of charge. You make a statement that the system should know that victims go back to their abuser. They continue to go back to their abuser. That is very true. It takes approximately 8 to 10 times for a victim to leave their abuser before they have enough strength to continue and to move forward. I get that. But there is also this cycle of joint abuse, joint domestic abuse involving both the male and the female, or whatever the significant others are. The fact that you say that in your statement, that the system should know the victims always go back. And I went back and I'm continuing to go back and I see that he can change and I want to be there to help him change. It sounds like you're playing the system. You know domestic violence, you know the facts. You've went through the CRA class, the Community Referral Agency class. You're spewing the things that you want the court to know or to take into account. I'm aware of those things. If you're aware of those things, you should have, you know those. You reach out to your advocate, you reach out to your friends, you reach out to your family. You don't continue to go back each and every time to the place that you were ordered to stay away from. That was plain and simple. Back in the 22 SC case, the small claims case, you were told to stay away from that house. Then back in the 23 restraining order cases, you were told specifically in that order in black and white to stay away from that house. I can't, and I believe I reprimanded the Haskins as well back then. I believe I told them the words that they cannot control Jordan. If Jordan is an adult and if Jordan wants to see you, that is for Jordan to do. They can't control him. He is an adult. They cannot control you. You are an adult. However, they can control, and this court can control whether or not you ever step foot on that property and you violated it. How many times? More than these 5 or whatever times are alleged here. More than that. I believe Mr. Haskins. I believe Jason Haskins when he says you were flaunting to him that you were sleeping in the same house. I believe him. I don't believe you. I don't find you credible because this has happened over and over and over again. And I had to be harsh with Jordan Haskins in his criminal case. I've held him in prison, or not in prison. Luckily, he didn't go to prison. I put him in jail 60 days, 90 days. I kept increasing those days so he can understand the significance of having contact with you anyway, because he had no contact, but then with you at this house. And when you go to this house, it's pretty much sticking your middle finger up at the Haskins. You're saying, I don't care. I don't care what you feel. I don't care what you think. I don't care that you own the property. I don't care that you support your son. I don't care that you do anything. I don't care that you exist. I'm going to do what I want to do. Because in that small claims case, there was criminal damage, there was damage to that property. You admitted so on the record of that damage. You admitted to try and pay for it. You admitted to try and work it out with the Haskins so you could pay for it, so it would go away. They more so wanted your behavior controlled, you away from that environment. They really wanted you away from Jordan. But they used the avenue that they could with regards to those damages and the eviction. That wasn't an illegal eviction. I sat on that case. I heard everything. That was not an illegal eviction. It is not. You had your time to talk. You did not. I read your multiple claims.
It wasn't filed for over a year after that.
Please don't
Your
stop.
Honor.
I told you to stop talking. Not your time to talk. I have so much empathy for domestic violence victims. And I believe that you were and could potentially still be a victim with Jordan. Again, I don't know. I'm guessing that this has never stopped. It has never stopped. You are addicted to this cycle. You are addicted to Jordan. You know he's not good for you. You know he's not good for your son. You know he's not good for your life, because look at where you are. Now you're a convicted criminal. I don't know what you had prior to this, but now you are a criminal forever and always. And Miss Mott, I'm going to guess, this is coming down really harsh on you right now, but I'm going to guess prior to Jordan, You were sweet and kind, and you were not retributive. You were not trying to destroy people's lives and their property and to do those things. Again, you and Jordan are gasoline and fire. Gasoline and fire. And if this doesn't stop, something more serious will happen. Something more serious will happen. Somebody could be injured. Mr. Haskins could have been hit by that car. You could have been here for a reckless homicide, substantial battery, multiple other crimes. If something were to have happened to him, he just had back surgery. And he should not have been standing in the driveway at that time after back surgery, but he thought he needed to do what he needed to do to protect his property. And I'm harsh on you right now, and I'm going to tell you right now, I'm going to guess that at one point in time, at one different case or another, the Haskins have thought that I've been harsh on them too. I have to look at the facts in front of me for the cases. This got out of control. Every single time you went over to that house, you made a choice to go over to that house, not only knowing it was against the Haskins' desire and their wish, it was against the law. It was against the law each and every time you stepped foot on that property. But not only did you step foot on the property, you did donuts, you did other things that caused havoc to that property, and it got you nowhere. It didn't get you any good. It puts you in the light of the person who is doing all of the wrong. If you and Jordan cannot stay away from each other, if you and Jordan must be together, it cannot be on this property. You cannot step foot on this property one more time. Miss Haskins at this last one could have been injured. And I did read in yours that you said that she was holding you down or they were pulling your hair. Well, they were calling 911 or calling the police. They were trying to get a perpetrator out of their house. You're shaking your head. No, you were.
They were blocking the door so I couldn't leave.
You should never have been there.
I understand that, Your
Not
Honor.
ever, never have stepped foot on there.
I know, I
But
get
that was your 20th time. And you're not getting it. You're just not getting it. You're risking your life. You're risking your son's life. You're risking your future, your reputation, all of these things. And I have to ask, is it worth it? Is it worth it? Is Jordan Haskins worth it? Because I don't think he is. Not for you. And hearing the recommendation, and Mr. Schmidt was saying, well, 30 days, is that going to be too harsh? No, not when we look at the factors in those things. In his argument, I'm thinking, is 30 days too harsh? Is 30 days too lenient? Because it happened over and over and over again, and it escalated. And I believe, again, Mr. Haskins, when he says he made those trips multiple times a week to try and circumvent this, to try and stop this, so you wouldn't have a clue when he was there. And I do believe his speculation that when he was sleeping in Jordan's bedroom, there was a different car there that you didn't recognize, and you thought it was another woman. And you went berserk. You went crazy. You did donuts in their yard. You could have been charged with criminal damage. on multiple occasions. So I have to look at this and I have to craft a sentence because this is serious. I have to craft a sentence that looks at you now, that looks at your past behavior, that tries to look at the crystal ball for your future behavior. And I need to protect the community. That means everybody as a whole, but in particular, the Haskins and this property. And to ensure that you understand that you'll get it. You'll understand you cannot ever step foot on that property. Never. If you do, there will be ramifications. The court, in trying to figure out and get a sentence that will accomplish all of the things, I need to look at also deterrence. I need to deter you from continuing to do this. I need to deter you from doing this. This is not a general deterrence where I'm deterring others, unless if we're looking at people violating restraining orders. I need to make sure I craft a sentence that deters you from doing anything further. That if you do this again, there will be serious consequences. I cannot extend the restraining orders at this time as the Haskins has requested, as they have requested. However, I can again craft a sentence that can try and meet the objectives of the victims, as well as the justice system. So in doing so, the court is going to do 2 years of probation, because that puts this out then to 2027. That puts us out to the length of the restraining orders, or close to, a little bit over. That is the longest that this court can go for probation. And with regards to actually sentencing, I'm doing an imposed and stayed sentence. If I were to do a straight sentence, even the straight maximum possible penalty, that doesn't accomplish and won't accomplish more protection for the Haskins and having the hammer over the head to ensure that you actually understand it, that you're not going to do it again. I have 25 CM30, which is count 6. And then I have the 2 other counts in 25 CM 125, which would be count 2 and count 3. In 25 CM 30, what the court is going to do is I'm going to do an imposed and stayed sentence of 6 months in jail. If you're revoked off of probation, you will sit 6 months in jail for that count. In 25 CM 125, count 2, I'm sentencing you to an imposed and stayed of 6 months in jail, consecutive to the other count. That means if you're revoked, you will sit a whole year in jail. That's a long time to have to think and to contemplate. For count 3, I'm sentencing you to 6 months in jail. That is concurrent to count 2, but consecutive to 25 CM 30. So again, if you're revoked off of probation, 1 full year of jail. That is a very long time. I am sentencing you to conditional jail on top of the sentence that I have already laid out. For 25 CM 30, count 6, 30 days of conditional jail. 25 CM 125, count 2, 30 days of conditional jail, consecutive to 25 CM 30. In count 3, 30 days of conditional jail, concurrent with count 2, but consecutive to 25 CM 30. 60 days of conditional jail. It hasn't been enough for this court to reprimand you. It hasn't been enough for this court to look you in the eye and tell you, stop, you cannot do this. It hasn't been enough for this court to tell you and to say, look, gasoline and fire. This is a very toxic relationship. It's a toxic relationship. It has caused not only Jordan Haskins to get into serious criminal trouble and to sit serious jail time, it has now gotten you into trouble, and you are going to sit serious jail time, which could be substantial if you violate your probation. While on probation, there will be absolutely no contact with Christy Haskins, Jason Haskins, or any of their family, including Jordan Haskins. So you'll figure that out. No contact with any of the properties, and that does include the properties listed in the injunction. 6050 Cherry Circle North in Hudson, 26996 County Road A in Spooner, 702 Walter Street in Spooner. Absolutely no contact. If you think you need to drive to the grocery store and drive by one of those properties, I'd find an alternate route. I'd go 40 miles out of your way instead of driving by that house or one of those properties. I am also ordering a mental health evaluation and follow through. I am ordering domestic abuse programming completion and follow through. Absolute sobriety. No alcohol, no illegal substances. Gainful employment. What was the longest time you sat in jail?
I don't recall, 30 days maybe. I don't know.
So you have a criminal history?
I got a misdemeanor once years ago for paraphernalia for, it was over 12 years ago, I think.
Wow, 30 days in jail for paraphernalia. They took that
Well,
seriously.
no, it was literally, I got arrested and then I just sat until I was sentenced pretty much.
Okay. Well, 60 days will be no piece of cake. I'm going to give you 30 days to report to jail. So you have 30 days to get your affairs in order. I am not approving electronic monitor at this time. Consider that. But at least at this time, there needs to be punishment. House arrest, electronic monitor is punishment, but it's not the same punishment. It doesn't have the same deterring effect, because then you can go about your normal life. You could have people to your place of residence. You could do fun things at your place. This is a deterrence. This is to deter you and to punish you from this continuous, ongoing, aggravated behavior. I will consider a motion for electronic monitor after 30 days. And again, why I am not considering electronic monitors, this county does not have the monitors that I would put you on. Because I want, if you are going to go on an electronic monitor, the county would need to order a different one, because it would need to be one that is GPS, that is put right on your ankle, that cannot be removed. So they can see exactly where you are at all times. The court is ordering $443 in fines and fees for the count in 25 CM 30, $200 DNA surcharge for the other 2 counts in the other case. I'm waiving the other court costs and fees. I don't think a financial punishment will have the same deterrent effect as having the jail time. I'm ordering your DNA. You must go to the jail and provide your DNA. You're going to need to have minutes so they know that you are not to be put into jail today, that you have 30 days. So when we're done, you need to come and get the minutes so that you can go provide your DNA. You would have the ability to request it be expunged through a written letter to the Department of Justice, not to the court, to the Department of Justice. The ticket matter is now dismissed as well and read in. You will have monthly payments beginning in November to be paid by the 15th of each month of $50 a month to be paid towards your court costs and fees. If you fail to make your monthly payments, you could get a warrant and sit an additional 6 months in jail. I'm going to have Department of Corrections collect that since you will be on probation for the period of 2 years.
Your Honor, so what's the grand total that I will owe? If you could.
$843.
Okay, I can pay most of it today.
Well, I do appreciate that. How much can you pay today?
I'll pay $450.
$450. If you can pay $600 today, I'll waive the rest. But I can't waive any more because that's all mandatory. You
We'll
can
do
pay
it.
$600. All right, so I will only assess $200 DNA surcharge per count, total of $600 to be paid today. And I'm doing that again because the financial aspect is not the punishment. The punishment is the jail and the potential significant substantial jail if you violate. I don't know if she has, I don't believe she has jail credit for here. Mr. Schmidt, what is the court missing? If you fail to pay, not only will a civil judgment be entered against you, you could sit up to 6 months in jail. Mr. Schmidt,
Nothing from me.
Mr. Felisky,
Nothing further. Thank you.
Ms. Mott. I want you to understand what I see and what I understand. And I believe to some extent the Haskins may have an understanding of this either, or two. Jordan Haskins is not 100% innocent in this. You have been a victim of him as well. He has asked you to go to the house. He has played a part of this. But you are the one who had all of the risk. And then you escalated it with Mr. and Mrs. Haskins. They're parents and owners of a property that are trying to do right. You are an individual in love and you are blinded by that. Ms. Haskins or Ms. Mott, you need to, I say need, and you should respect yourself more. This is not something that you should want to be involved in. This is not a relationship that brings you happiness. It is not a relationship that brings you stability. It has only caused destruction and devastation for both of the families. I don't have a doubt in my mind that you are a good mother. I read it in your letter that you are giving your son stability right now while you're going through instability. That's a hard choice to make. I have a good feeling that once you're able to disconnect and get away from Jordan and to get some therapy, you're going to be a different person. And I don't think the Haskins are going to have to worry about that. You have to recognize your worth. And so far, you don't believe you have any.
Your Honor, in light of Ms. Mott's advice to me regarding potential property remaining, a personal property of hers remaining at Haskins property, we are asking permission for one visit accompanied by law enforcement for her to retrieve her personal items.
I don't believe I can do that in this order without the Haskins' approval of having law enforcement and having a visit to go there. I can ask them if they would approve of one visit with law enforcement present to retrieve any belongings she may have there.
I'm just mainly concerned about my grandma's things that are still there.
Sounds like she has personal property of her grandmother's that is still there. Would she be able to retrieve that with law enforcement, Mr. Haskins? And you may still be present.
Yeah, that's fine.
Yes. You may do so within the next 30 days, all right, before you turn yourself into the jail. And you need to make sure that's prearranged with the law enforcement. And Mr. Kwinsky, I'm going to say that it needs to be prearranged with you and Mr. and Mrs. Haskins, okay? That's okay, Mr. and Mrs. Haskins, to speak with Mr. Kwinsky about that? Okay. All right. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I believe that covers everything. And we are adjourned. Thank you.
For now, that's where we'll leave Judge Mogan and our defendants in Burnett County, Wisconsin, and we'll say goodnight. But there's always more, because every day in the USA, people find themselves in court.